I'm Paul Smith, the Vice President of Litigation and Strategy at the Campaign Legal Center in Washington, D.C. We want to talk today about the cases pending in the Supreme Court about electors, presidential electors, and whether they have a right to vote for whoever they want to vote for. These cases are going to either say that states can bind electors to support the candidate that put them on the ballot, that pledged them, or that they can do whatever they want, and that will create a certain amount of chaos. The argument for allowing electors to be faithless, as the term goes, stems from the notion that as the Electoral College was originally conceived in 1787, the framers intended it to be a bit of a deliberative body to kind of decide based on its own judgment who the right president should be. But ever since about 1800, it's been very clear that everybody assumes the electors are simply mechanical, that they simply vote the electoral votes allocated to each state. If the court were to go back to the original intent and say, even now, after all of this history of more than 2 centuries, electors are free to vote their conscience, we'll have a multitude of problems in our presidential elections. There's no law to regulate anything that you would want to regulate about free agent electors, such as conflicts of interest. More importantly, even than that, is if you have a very close outcome in the Electoral College, there will then be a period of a month or two when all sorts of pressure will be brought to bear on electors to try to change their vote and change the outcome. If we get to the point where the Supreme Court has said that electors are free agents to elect anybody they want, then all hell is going to break loose, and we're really hoping at the Campaign Legal Center that that doesn't happen.